welcome to Go Vote Omaha, presented by the League of Women Voters of Greater Omaha. I'm MaryLee Moulton, a member of the League and your host. The League is nonpartisan and does not support candidates or political parties. Each week, we talk about important public policy issues, and we hope you'll discuss these issues, and come election time, you will be ready and willing to go vote. Our guest today is Judge Laurie Smith Camp of the U.S. District Court, District of Nebraska. She is going to talk to us today about the 19th Amendment and Nebraska's role in its passage. Judge Smith Camp is a graduate of Stanford University and received her JD from the University of Nebraska College of Law. She was general counsel for the Nebraska Department of Corrections Services, chief of the Civil Rights Section of the Nebraska Department of Justice, chief deputy attorney general for criminal matters, and was a developer of the Haymarket District in Lincoln. Laurie Smith Camp was nominated by President George W. Bush on September 4th, 2001, and was confirmed by the Senate on October 23rd, 2001, by a vote of 100-0. She served as Chief Judge of the U.S. District Court, District of Nebraska from 2001 to 2018, and assumed senior status on December 1st, 2018. Judge Smith Camp is the convener of the 8th Circuit Judicial Conference in Omaha in August of 2020, and the League of Women Voters will be working with her on programs and exhibits for the conference, which will celebrate the centennial of the 19th Amendment. So thanks for being with us, Judge Smith Camp. Nebraska just celebrated the 100th anniversary of its ratification of the 19th Amendment. You were there to help celebrate with
Absolutely.
us. And as we head into 2020, why is it that you want to have a focus on the 19th Amendment?
Well, you and the others in the League of Women Voters may have noticed that over the last few years, our society seems to have become a little more polarized. Mm-hmm. As a judge, I'm not running for political office. I cannot be involved in politics at all. But I thought, what can I do that is positive? And I can emphasize something about our history, our American history, of which we can be very proud. We, as you noted, are celebrating the centennial of the ratification of the 19th Amendment. We just celebrated the centennial of Nebraska's ratification of the amendment. And then next August will be the centennial of the national ratification. Mm-hmm. But that process leading to that ratification took many, many decades. Many women and men worked very hard to make that happen. And the message is historic. It's a message of courage and determination. It's a message of inclusion, diversity, and representative government. And that's why I want to be involved, as the League of Women Voters is, in getting out this very positive message.
Right. So the road to suffrage was a long one, and it was intertwined with the fight against slavery. Many of the suffragists were also abolitionists. Can you start by talking about the previous constitutional amendments that extended suffrage to African American men, because that's where we started off with?
Certainly. When the women's rights movement began in the 1840s, that wave of the women's rights movement and the movement towards suffrage, people who were working toward women's suffrage were also working toward abolition and for suffrage for all people of all races and colors. The women didn't get there quite as quickly as other groups did, at least as far as the constitutional amendments were concerned. First, we had the 13th Amendment in 1865, which acknowledged that involuntary servitude was unconstitutional. Mm-hmm. Then in 1868, the 14th Amendment was adopted, and women were very optimistic about the language of the 14th Amendment. I think we might have a slide on that you can show with the language. Most people, when they think about the 14th Amendment, think about the first section of the amendment, which includes 4 very important clauses: the Equal Protection Clause, the Clause on Privileges and Immunities, the Citizenship Clause, and the Due Process Clause. Mm-hmm. But if we look at the second section of the 14th Amendment, it includes the word male for the first time in the United States Constitution. And that section was designed to discourage states that had been formerly in the Confederacy from denying the right to vote to African American males. And it provided that if any state did deny that right to African American males, then the representation for that state in Congress would be reduced proportionally. Women were discouraged that the language of the 14th Amendment was worded as it was, but it didn't stop Susan B. Anthony and other women from trying to go out and vote on the theory that they were citizens and that they could not be denied the privileges and immunities of citizens.
Okay. So how were these rights curtailed then in the slaughterhouse cases? Because it goes back and forth, and in 1873 we had that case, that case. So.
Right. In the slaughterhouse cases, that was the first time that the U.S. Supreme Court had the opportunity to analyze the language of the 14th Amendment. And actually, they also analyzed the language of the 13th Amendment, involuntary servitude. It was a case out of New Orleans where a group of butchers were upset that the city of New Orleans had established a monopoly for slaughtering animals. They wanted to have their own slaughterhouses. And this was essentially a monopoly created for public safety and sanitation. The men who wanted to operate their own slaughterhouses alleged that this new law in Louisiana was a violation of their right to be free from involuntary servitude, their right to due process, their right to privileges and immunities, their right to equal protection. And the Supreme Court split 5-4 on that case. The majority of 5 construed the 14th Amendment provisions narrowly and said, no, this isn't what the 14th Amendment means. And they upheld the statute. The other 4 justices said, we would have found in favor of the plaintiffs on all of their arguments, and no state has the right to deny any man the opportunity to engage in any occupation he wishes. Now, to follow up on that, the same year, just a few months later, the Illinois versus Bradwell, or Bradwell versus Illinois case
so
was
now
issued.
A woman makes that claim, and
now
we'll see.
A woman made the claim, and the remarkable thing, well, she wanted to be a lawyer. She was a lawyer and wanted to practice law in the state of Illinois, and Illinois said, no, you're a woman. You can't practice law, even though she was highly qualified. There was no dispute about that. The interesting thing about the Bradwell versus Illinois decision is we no longer had the 5-4 split. We had 3 of the justices who had dissented in the slaughterhouse cases coming over to the majority saying she does not have the right to practice law, but their theory was she was a woman, therefore she did not have the right. The one dissenter was the Chief Justice Salmon Chase, who said, I dissent from all of the above opinions. And then a few days later, he died. I think he would have written a longer dissent if he had not been so sick. So that's the history of slaughterhouse and Bradwell versus Illinois.
So time moves on a little bit, and we get to 1875, and we have this Minor versus Happersett case. So where does that play into things?
Right. Well, in Minor versus Happersett, Virginia Minor, who was out of Virginia, decided that she was going to try to vote under the theory that the 14th Amendment said that all citizens, all people born in the United States or naturalized, are citizens of the United States, and that no state can deny citizens the privileges and immunities of citizens of the United States. So she and Susan B. Anthony and a number of other women thought that this entitled them to vote, or at least they were going to try to see if they could use that theory, and she was denied the right to vote. Well, her husband was a lawyer, and so he brought this action against Mr. Happersett, who was the one who denied her the right to register to vote, took the case all the way up to the U.S. Supreme Court, and essentially the U.S. Supreme Court said, nothing in the U.S. Constitution gives anybody the right to vote. Amendments such as, well, the 15th Amendment that we didn't talk about yet, but which was ratified in 1870 and said that no state can deny anyone the right to vote based upon race, color, or previous condition of servitude, does not create a right to vote. It just says states cannot deny the right on a certain basis. And because there was nothing in the Constitution saying a state could not deny the right on the basis of sex, the state of Missouri could deny Virginia Minor the right to vote on the basis of her sex.
But she was still considered a citizen of the United States. There was no doubt about that, though.
There was no doubt that she was a citizen because she was born here and under the jurisdiction of the United States. Now, if you were born on an Indian reservation, you were not considered to be born under the jurisdiction of the United States, which is also language in the first section of the 14th Amendment. And so Native Americans did not attain the right to vote until that was established by Congress by statute, and I believe that was
1924.
1924,
right, which is 4 years even after women get the right to vote.
Right.
So okay, so it's obvious that the path was a struggle. So let's turn to how Nebraska participated in all of this, because Nebraska had a big role to play in the whole concept of women's suffrage and even in the territorial legislature. So why don't we start with Amelia Bloomer, and she came and talked to the territorial legislature here in Nebraska in 1855.
On July 4 of 1855, Amelia Bloomer came over from Council Bluffs to the new territorial capital in the city of Omaha and gave a remarkable speech. I guess she was a fabulous speaker. She persuaded many of the legislators in the territorial legislature that women should have the right to vote. And the lower house of the legislature actually passed a bill that would have authorized that issue to go to a vote of all the voters in Nebraska. It did not get to the upper house yet because the upper house was finished with its session before that they could debate that. But everyone was very optimistic that Nebraska was going to be the first.
And they would have been the first pretty much anywhere if they had done that.
In 1882, they were on the cusp of being the first state in the Union to authorize women's suffrage, recognize the right of women to vote. The territory of Wyoming had already recognized that right, the territory of Utah, but no state had yet recognized the right. And in Nebraska in 1882, both houses of our legislature, of course that was before the unicameral, enacted legislation that would authorize women's suffrage. It was signed off by the governor and it was going to a statewide vote. So Nebraska was the focus, and in the fall of that year, both of the national women's suffrage organizations, the American Women's Suffrage Organization and National Women's Suffrage Organization, both came to Omaha for their national conferences to push this legislation through.
So Susan B. Anthony, Elizabeth Cady Stanton, Nebraska was ground zero at that point.
Absolutely, and Virginia Minor came up here too.
Yes.
So it was, and I think that also Lucy Stone was here, if I remember correctly. So it was a big deal.
Right. But unfortunately,
it went to a statewide vote, and it was defeated in about a 2-to-1 vote. Remember that only men were voting.
Right.
And although Susan B. Anthony wanted to be optimistic about the vote being passed, she did write to one notable Nebraskan who was a champion of women's suffrage and said she feared that the men who wanted grog shops, gambling houses, and brothels would vote down the women's right to vote because they were afraid that women would undermine those three activities.
Right, and women were very active in trying to pass, laws to keep people from, trying to get liquor out of their lives, because it was not a good thing for women at that point.
Yes, certainly the women's rights movement and the prohibition movement overlapped considerably.
And this kind of sets a pattern that Nebraska has then, where they do vote, and it keeps getting closer, but they're not quite there yet in trying to get the public, the general population, to agree with it. Now, one of the major opponents of suffrage was Edward Rosewater of the Omaha Bee, and he opposed suffrage. Why was he involved with some of these grog shops and things like that?
Well, Edward Rosewater was a very interesting character. At that point in time, 1882, when the national conventions came to Omaha, and Omaha, or Nebraska, had the opportunity to be the first state to authorize women's suffrage, he debated Susan B. Anthony, and he was the anti-suffrage spokesperson. He was a very wealthy man. He had made a lot of money in the telegraph industry, and he ran the Omaha Bee, which was one of the two largest newspapers in Omaha. He was a very powerful man. And when he spoke on the subject, he said that, I'm going to quote, "In my estimation, the highest aim that a woman living in this country may have, more than she could achieve by enfranchisement of her sex, is to be the mother of a manly man." So he certainly had personal attitudes about the role of women and the role of men. And then later in his career, he was very closely aligned with liquor interests.
Right, and that kind of leads us to Denison, who was kind of a boss in Omaha at the time, who was also aligned with those liquor interests. And they really continue to try to keep blocking women from getting the vote because they are really concerned that women are going to do something about all of this liquor.
Yes, Tom Denison and his partner Billy Nesselhouse, who had a lot of expertise in grog shops, brothels, and gambling houses, formed an alliance with Rosewater right around the turn of the century, after Rosewater had unsuccessfully tried to extend the Trans-Mississippi Exposition for an extra year to celebrate American imperialism. And he ended up losing a lot of money on that event, but Denison and Nesselhouse made a lot of money, and they decided to form an alliance. The Omaha Bee could be used to assist the political interests that they wanted to promote. And although Rosewater died a few years later, his son, Victor Rosewater, continued to operate the Omaha Bee and continued that alliance. And the Denison-Nesselhouse Rosewater machine really was not ended until about 1933.
Okay. Now, the 18th Amendment does pass, and prohibition comes into the law, and that has a powerful impact then on Nebraska and suffrage too. And the political machine winds up trying to override municipal suffrage, which the Nebraska legislature passes in 1917.
Yes, as far as prohibition is concerned, Nebraska was a little ahead of the curve in deciding to enact prohibition, and Nebraska had prohibition as of May 1st of 1917. Then the 18th Amendment was ratified in January of 1919 to take effect 1 year from that date. The women suffrage for municipal voting took place, was enacted in 1917, and that law was passed by the Nebraska legislature, signed by the governor, and women received as much suffrage as they could receive without having a statewide popular vote.
Right.
So they could vote in they were supposed to be able to vote in municipal elections as well as for presidential electors through that statute. But the liquor interests didn't like that idea, and they decided they would use the referendum process to gather petitions, and if they could get almost 30,000 signatures of registered voters to get this issue put out to a referendum vote of the general population, they could actually suspend the enactment of that law or the enforcement of that law until the referendum vote took place. Well, groups associated with the predecessors of League of Women Voters took action to find out if these signatures were actually legitimate signatures. And in the research that they did, painstaking research, they found, no, these addresses weren't accurate. Some of these people were dead.
Right.
Many of the signatures, page after page, were in the same handwriting. And they showed the court that this was a fraudulent process to try to deny women the vote. And so ultimately, I believe that backfired against the people who opposed women's suffrage because of the lack of fair play.
And so you kind of have a personal connection to the Rosewater Denison kind of downfall at the end. Can you tell us a little bit about that?
Well, my grandfather, Robert Smith, had a grocery store which was located right next door to the Budweiser Saloon at 14th and Douglas Street, where Denison had his main office. And people who would come in to pay money to Denison for money that they owed him for gambling or other vice activities would come to the grocery store and ask for groceries on credit. And my grandfather was pretty generous, but he had a very negative attitude about Denison and his operation. So for the next third of a century, my grandfather was probably the principal anti-Denison figure, at least when he died in 1951. That's what the World Herald said. He served as clerk of the district court for most of that period of time. My father went to law school and was told he needed to come back and work for the U.S. Attorney's Office, and that he had a job to do, which was to essentially bring down the Denison machine. And he came back and worked on that project, and he was the prosecutor in the trial that took place at the end of 1932, which was successful in exposing the activities of Denison and Nestle House and 57 co-conspirators.
Cool, that's a great story. Now, Nebraska was the 14th state to ratify the 19th Amendment. Why don't we talk a little about the 19th Amendment itself, because it's a pretty simple amendment. And I think they'll put it up for us.
Okay, well, I'm going to try to recite it out of memory. I'll do my best. I believe that it says that all persons who are citizens who are born in the United States are citizens of the United States, and no state or the United States or no state will deny any citizen the right to vote based upon sex, or ends on account of sex.
On account of sex.
I'm sorry.
Yes, that's okay.
It's exactly the same as the 15th Amendment, but it adds one word, which is sex.
Right, on account of sex. Yeah. So that basically changes everything, and women are then allowed to vote. But I was really surprised when I was doing research that the 19th Amendment was actually challenged in court, which I thought was really kind of interesting.
That's true. There was a fellow who was a judge in Maryland who did not like the fact that women had attained the right to vote through this constitutional amendment, and he brought an action challenging that on 3 grounds. He said, first of all, that the subject matter was not appropriate for a constitutional amendment. He said that it was improper for states to ratify the 19th Amendment when their own state constitutions said that women could not vote in that state. And then he challenged a couple of states, including Tennessee, who had voted to ratify the 19th Amendment, saying that the procedural process that they used was in some way flawed. And the U.S. Supreme Court rejected all 3 of those arguments and said, no, it's
and it was unanimous?
Yes, it was unanimous.
Okay,
yes.
That's good to know.
Yes, that's right.
So having the right to vote was just one step in women's equality. So tell us about Reed v. Reed, which moved things even more forward for women.
Well, we mentioned the slaughterhouse cases in 1873, and there's one line in the slaughterhouse cases where the author, Samuel Freeman Miller, who was the first justice from west of Mississippi, said, "We doubt that the Equal Protection Clause will ever be used for any purpose other than applying to people who had formerly been slaves and their descendants." In Reed versus Reed, the Supreme Court recognized for the first time that the Equal Protection Clause applies to women and that states have to have some rational basis for treating women less favorably than men.
Okay.
And that was, I believe, 1971, so almost 100 years after the slaughterhouse cases and more than 100 years after the 14th Amendment was ratified.
That's a huge difference, that's for sure. Now, the 19th Amendment gave women the right to vote, but other Americans had to wait even longer. Can you talk about the 24th Amendment and the 1965 Voting Rights Act really briefly?
Well, under the 24th Amendment in 1964, the amendment provided that poll taxes cannot be used to deny people the right to vote. Later on, the Supreme Court also said that poll taxes in state elections cannot be used to deny people the right to vote. The 24th Amendment was really dealing with federal elections. And then with the 1965 Voting Rights Act, Congress said that literacy tests cannot be used as a qualifier for voting, and set up a mechanism for federal oversight of voting in the states to ensure that people weren't being denied their right to vote based upon impermissible grounds.
Okay. And then the Civil Rights Act in 65.
Well, that's the Civil Rights, well, this was the
Voting Rights Act,
1965 Voting Rights Act that said no literacy tests.
Oh, okay.
The 64 Civil Rights Act was dealing with access to jobs and facilities.
Okay. So in August of 2020, you are going to have a conference here in Omaha, and it is going to be talking about the Centennial of the 19th Amendment. Can you just give us a real brief preview?
Yes, we're excited about hosting this conference. It includes all the states within the 8th Circuit. Lawyers are invited as well as judges. And for those not familiar with the 8th Circuit, it includes the Dakotas, Nebraska, Minnesota, Iowa, Missouri, and Arkansas. We expect a wonderful turnout near the riverfront. I won't mention any particular facilities that we're using. Ruth Bader Ginsburg will join us. We're very excited about that. And we have a number of wonderful authors and other speakers who will be with us, and many of them will be doing community outreach. So there will be opportunities to hear some of those great speakers, including Elaine Weiss, who's the author of The Woman's Hour.
Yes, I'm talking about the vote in Tennessee, so that put us over.
Right.
Well, thank you so much for coming. We really enjoyed hearing about all of this. For the League of Women Voters of Greater Omaha, I am MaryLee Moulton, and remember to go vote Omaha. Thanks very much and good night.